Welcome to the Turnaround Podcast with your host, Stephen Phillips. In each episode, Stephen speaks to experienced practitioners who discuss their careers, key moments, challenges, and lessons learned in financial turnarounds and business restructuring. Join us as we unravel the secrets to turning struggling businesses into success stories. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, frylibertas.com. Now, here's the host of the Turnaround Podcast, Stephen Phillips.
And welcome to the Turnaround Podcast with me, Stephen Phillips. My last show featured Lisa Rickleton, who discussed her working life as an insolvency practitioner. This week, I turn to somebody who has a very different focus, somebody who has been a CEO in a major turnaround and has now moved to the advisory side. John Roche is the former CEO of Seadrill Partners Limited, latterly Aquadrill. Whilst CFO and later CEO, he steered SDLP, which Seadrill Partners was known as, through a tricky period, insulating it from the contagion of its parent's bankruptcy, and later he helped steer it through its own restructuring through a Chapter 11 process. I helped the board through the first stage of SDLP's turnaround journey, and I picked up again with John quite recently, as he has since joined a restructuring boutique called Province, which is expanding into Europe. John Roche, welcome to the Turnaround Podcast.
Stephen, thanks for having me.
Well, it's great to have you on, John. I asked the same question of all my guests because I think it's a really interesting one, which is, how did your career journey start?
Yeah, so Stephen, I have caught up on many of your previous broadcasts. Greatly enjoyed them, and a common thread I'm hearing from a lot of your guests is the word coming about into restructuring. I guess by accident, a lot of people are saying, and I probably fall into a very similar camp.
Yes.
Going down this path, I got my start on the buy side at Morgan Stanley. Spent almost a decade in investment banking after that, and then I joined one of my clients,
Okay.
Seadrill.
Yes.
And so developed a relationship. I was always covering oil and gas. That's kind of where my heart was, and I joined Seadrill really at the time where the industry was growing rapidly, acquiring companies, heavy degree of financing involved, and it was a very dynamic and interesting situation, and really drawn towards it. I think you alluded to it in your introduction. In regards to a period of tricky situations in the offshore drilling space. I think I might qualify that as more like a decade.
Yes.
And that was ultimately the path into restructuring as we managed the company through a very prolonged and deep downturn.
So, it might be worth helping the audience explain what a drill ship company is. What is Seadrills? What does it do? And in fact, I suppose, why is this type of company or this quite susceptible to restructuring process or in need of restructuring process quite often?
Yeah. So Seadrill is an owner and operator of drill ships and jackup drilling rigs. These are the big offshore vessels that explore and develop for hydrocarbon. Customer base are oil companies, both integrated and independent. But Seadrill was more than simply an owner and operator of these assets, right? I mean, it was a big participant in the build cycle. Okay, so contracting with shipyards, building the assets, financing the assets, getting them on water, and then running them. was very impressive.
And these things just there may be people who don't even have a clue what this is, but these things are massive bits of steel, effectively, that help in the exploration of offshore oil.
Absolutely. Just to put some context on the size, I think we can all understand dollars. So when we were constructing these vessels, oftentimes it would cost $500 million a piece.
Yep.
At least the drill ships. Just to put some context around that, that's kind of in the the 2014 build cycle. I couldn't price that today because no one's building them today, but that's kind of the context of the machinery we're talking about. So yes, these are massive. Call it really like floating cities out there that are drilling for oil and gas.
Yeah, got it. And you, so you joined the company. You said there's sort of 10-year process going on. So let's fast forward. I guess to about 2014, 15, oil price goes down. What's that doing to your business?
Yeah. So, well, I think if we just take a look at the business itself, right, and why it might be. First of all, look, everything related to oil and gas is cyclical, right? We know that oil prices and commodities in general do they go up and they go down, and these things are cyclical. I think to add an additional cyclical element to the offshore drilling industry is the build cycle. Yeah. Okay, so it's got its own cyclical elements that are obviously overlaid on top of the commodities. Cyclical elements. So when we saw that the oil price decrease, this actually came at a period of time right after a massive expansion in the available supply. Yep. And so that downturn really picked up steam. When you see spending pull back from our customer base, and then you add onto that the fact that there's now a very oversupplied market, and a whole lot more supply than you had seen in prior downturns. And this was driven, the build out was driven by several factors. There was developments in technology. High oil prices had made a lot of the offshore basins economic, and so you really played into those elements. But when it stopped, what ultimately happened, and I think when we look at the elements of the industry that to your point, lends itself towards challenges. These assets are incredibly expensive to have go idle. Okay, salt water and steel do not mix well, and when these assets are not operating and they're idle for some time, there is a big capital expenditure required to get them back on the water. And so what a lot of asset owners will do is say, okay, well, if it's going to cost me tens of millions of dollars in 3 years' time if I go idle, wouldn't it make more sense for me to work at operating cost for a period of time to avoid that expense? Perhaps it makes more sense, to work below operating cost. And so you see a lot of rig owners doing that math. And that is really, in addition to the commodities downturn, that's what really led to a very deep and prolonged downturn in the offshore drilling space. And so that I think that's where we met on kind of called the first leg in 2018. Where when I was CFO of the company, and what we ultimately had to do was insulate ourselves from our parent company, and the big difference there was that, if you recall, Seadrill Partners had it was an 11 rig fleet, and we had long-term contracts, right? So we said, look, from our contracted backlog perspective, we think we're going to see through this. We don't need a restructuring. What we need to do is insulate from our parent company that was going to go through a Chapter 11. Yeah.
So I guess, as you say, that's where we met, and I was effectively helping you to do those sort of insulating type of transactions, making sure that the board that you were on was separately advised and was behaving in a way that was, not sort of just listening to what its parent company was doing, and also making sure that there weren't defaults that were happening. So that was a period where the parent went through its restructuring. You successfully allowed your company to sort of go through that process without the cross-contamination, as it were. Fast forward a year or two after the parent had gone into its process and kind of come out. What then happened to the company that you were on?
Yeah. So Steve, if I may, perhaps if we take it before we go to what happened after, I think talking a bit about some of the steps before
Yes.
actually realizing that there was a process we had to insulate from, and some of the steps that I think were critical to being prepared for that process, that the 2018 process. And so, one of the things that myself and our independent directors did really I became CFO of the company in 2015, so 3 years ahead of any troubles brewing, and there were really no signposts that troubles were brewing. Okay, but when I sat down with a clean sheet of paper coming in from kind of an external third party, what I didn't see was a clear line of demarcation between parent and daughter. And I said, look, if there is ever a time in the future, knowing full well this is a cyclical industry, that we are going to have to do something, it would be very advisable to start that preparation now. And so we did a couple things. We increased the independent elements of our board over time. These were not drastic steps or anything like that. Cannonballs into the deep end rarely work, and it was not required. Also going and ensuring that we had a good understanding of the management services agreements and the cash flowing between the two entities, monitor it, track it, understand the interplay that would have with our capital structure. Because at the time, while Seadrill Partners always had a separate board, separate legal entities under its umbrella, a separate listing, what we found is that a lot of, say, the back office really didn't treat the two companies different, which wasn't necessarily a problem until it becomes one. So why don't we put in some controls, some understanding, and really educating the organization on how this works. And when money's flowing from this entity to this entity, we just have to be aware. So it was a matter of really building that awareness. We also had a rather complex setup with our financing structures, not only co-guarantee structures with the parent, which will come on, we solved in the first round of the restructuring, but also crisscrossing and overlapping capital structure over our organizational structure. And what I mean by that is the normal flow of funds through the business, operating flow of funds, would oftentimes trip through, say, our P baskets. And it really prevented us from really being able to institute what I called normal operational, financial operations efficiency measures, say a cash pool or something like that. So it became a process of understanding, implementing what we could with the constraints that we had. But without putting in those steps and having that understanding, I think we would have had a much more difficult time when we sat down in 2018 to say, okay, how do we ensure that we have the right controls in place, that we are going to be able to clip the guarantees in an efficient manner and really a non-disruptive manner, and carry on with our business. So we did that, which brings us to call it the 2019 timeframe.
And actually, before you do, I suppose a bit of slight self-promotion, which is obviously one of the things that I've been advocating over many years is in these kind of situations, you need separate legal counsel, because I think originally the two firms were, represented by one firm, and a very, competent, incredibly impressive firm, but having some separate legal counsel was obviously part of your process of insulating the company. But anyway, enough self-promotion. Over to you, John, to tell us about 2019.
Yeah, but I don't want to gloss over that point, because I do think it is important. Okay. And when you can approach your stakeholders and say, look, we've thought of all these things, we've taken actions operationally, organizationally. I'm talking about now the company, right, with the independent directors, separate teams, et cetera. But we've also had separate advice, to make sure that we're looking at this from an independent perspective. And I think if that's your first message, if that's conversation number one with a stakeholder versus conversation number 10, I think the next conversations are really much more fluid. And you can put all of that, all of those questions behind you. And look, I think it's incredibly relevant in situations today. And as we look at companies that may not be in a distressed state today, but you kind of look out with debt maturities, 18 months, 2 years time, and a lot of the conversations I'm having today is let's think about where the problems might arise. What steps can we take today to make those first conversations with creditors, if they happen, go more smoothly and make it a more efficient process? And you know what, if they don't happen, well, that's great too.
Yeah, I think I guess to expand on this, I think what we are seeing is the private equity industry often does get its arm around its portfolio companies and is very, pretty domineering, quite understandably, when it's taking over a company, puts its own people on the board, etc. And then actually, if a restructuring takes place, you do have this sort of slightly odd dynamic where there needs to be a sort of slightly pulling apart of the two roles and an understanding that the two entities, the private equity house and the portfolio company, are different. And I suppose this analogy that we're making, or the analogy I'm making, is very similar to the situation you're talking about, which is at some point, you perhaps need to recognize that the two entities may not be together again, or the relationship needs to change in some ways. So I guess we've taken a long time on that, so we probably should talk to what happens next. But I think it's a good it is a good point that you've made.
Yeah, I think it was a worthwhile diversion. But kind of fast forwarding to 2019, when I became CEO of the company, I mean, really this was a restructuring mandate. Okay, the market had not recovered. We had we consumed a lot of the the long-term contracts, long-term contracted backlog that we had. Really just a function of time, and also a function of not replacing that backlog. Okay, we just simply hadn't seen the volumes return to the market. And so
what happens? I think I understand the industry because I was involved in Ocean Rig, which was another one that sort of needed restructuring. So you have these pretty long-term contracts, don't you? I mean, they're 2, 3, 4 years often, and they can often be struck either at a sort of low point in the cycle or high point in the cycle. But I think what you were saying is that many of your ships just didn't have a contract. That must have been very, very expensive just to have this hulking bit of steel, a lot of security, a lot of sort of just maintenance to be done just to keep it there. And I guess fast forward to 2019, you're in trouble.
Yeah, well, it was forecastable, right? I mean, we could see we didn't have we still had 4 ships on contract. In 2019, we were actually in the fortunate situation of having struck long-term contracts at good times in the market. Okay,
Right.
because
Okay.
they can be short, they can be long, but SDLP's model was to acquire long-term contracts from its parent. And that's what we did over time when we were still in acquisition mode. And so it was very forecastable, right? I mean, the lead time on securing a drilling contract, kind of on the short end, can be 12 months. Realistically, you know what it's going to look like, probably 12 to 18 months ahead of time. And so, I could say, look, here's the assuming operations continues, which I don't want to diminish the importance of operations here. Okay, because that's important to perform on your contracts. But assuming that carries on, I can forecast that we're not going to be replacing the white space, if you will, that we require to service our debt, okay, or to refinance our debt. And so it was all very forecastable, and this is what me and the board set out to do. And in 2019, we said, look, we have a capital structure that is going to have to be dealt with, and at the time, we had a $3 billion term loan, okay, secured on a certain set of assets, U.S. law, and then we had several what I'll call legacy secured bank facilities secured against a separate set of assets. The key difference between these two stakeholder groups was that the legacy bank debt was were amortizing loans. And so by the time 2019 rolled around, they were probably around 50% LTV. Yeah. Whereas the term loan was non-amortizing. And so we were probably looking at something, it was, call it 150, 150 times LTV. But definitely very, very low equity value. And so what we decided to do, and also the term loan was a very concentrated holder base where, 5 holders probably comprise about 80% of the loan. So what we decided at a very early stage, again, building on all the things we did from an independent standpoint. So we did have, I think, a good amount of credibility with our stakeholders, in particular the term loan. We asked them for permission to use some of their cash to take out the bank debt. And we said, look, the equity value is yours anyway. I think this is going to go a whole lot better if we consolidate everything under one collateral group and then sort out the capital structure after that. So that's what we did. So step one was consolidate the capital structure, which made life a whole lot easier, right? Now we had all of our assets under one collateral group. Cash was able to flow freely throughout the organization. So operationally, it was great. And then we kind of went on to phase two. And one of the key elements of phase two was really the management services agreements. Okay. And what our lenders were really interested in is what are these market based? Okay. And we had done a good body of work to assess if these were market based. We looked at several alternatives. This is work we'd been doing for some time. Okay, so we kind of always had this bubbling in the background. Say, look, if we did need to renegotiate our management service agreements, we sure better have another alternative. All right, and so that was going on in the background. What really happened is, Seadrill had to go through its second restructuring. Okay, in 2020, 2021. And so what it really created was a dynamic where we said, okay, if the parent company is going through its restructuring again, we have a plan for our capital structure. How is all this going to work? Is it are we going to bring the companies together? Are we going to look at alternatives? And part of that evaluation obviously is looking at other alternatives. And so what we found is that there were several alternatives in the marketplace to operate our rigs. And so, we thought these were more attractive alternatives, both from a cost perspective, but also from organizational perspective, because a lot of the companies we were looking at had either restructured or were further along in their restructuring. And so we used the Chapter 11 processes to equitize the debt. Okay, yep. which was relatively straightforward, right? I mean, we had a consolidated lender base, and they wanted to emerge debt free. So it's really just a question of how much cash do we want to have at emergence. But when we use the Chapter 11, which is very useful, is really getting that safe breathing space to do two things: enter into management service agreements with 3 other drilling companies. And when I say management service agreements, just for ease, people that would run and would operate our rigs. Okay. So we entered into 3 separate arrangements with 3 different companies to operate the rigs. What that entailed is unplugging the rigs from the Seadrill operating system and replugging them in to 3 others. Vast oversimplification. It's a rather complicated process, but that's what was done. Yeah. We also had to stand up an independent company that we ultimately renamed Aquadrill. And so, when I say stand up, I mean, put in place all the, back office finance, all the corporate HR, employment contracts, and really build out an independent company. And so that's what we did.
Can I ask you, when we spoke yesterday in preparation, you talked about there was the importance of the automatic stay in Chapter 11. So that might be a feature that you might want to emphasize here.
Yeah, I think it's always going to be case specific. All right. I think that in our case, having the term loan was U.S. law, right? New York law. So that lended itself to Chapter 11. But in our specific case, the operational elements, and look, I think that this was a very unique case in that regard, right? Using this to really carve out a subset of a company and launch an independent company. When we looked at the automatic stay, we kind of said, look, putting aside the natural path because of the jurisdiction of our debt, there were very few processes in the world that would really provide this breathing space. Okay,
essentially, it stops people attacking the company, taking action against the company.
Correct. And look, there's in many jurisdictions there's mechanisms for preventing that on the creditor side. Okay, state enforcement, et cetera. But when we're talking about the operating business, ensuring that customers don't stop paying us, walk away from the contracts, ensuring that vendors will continue to supply us, ensuring that that the seamless handover of rigs from one company to the other. I think that with the those unique factors, really. I mean, it really showed the benefit of and the power of that automatic stay to perform that type of corporate restructuring.
Got it. Yeah. I mean, I guess that that you have seen other jurisdictions used, like we used the Cayman scheme of arrangement in Ocean Rig, but I think people underestimate quite how useful that automatic stay is, because effectively, if people do start attacking the company, even if it's in another jurisdiction, if you're in Chapter 11 and you start attacking a company, you may find yourself in contempt to the US bankruptcy court, and no one wants to be in contempt. So it can be a very, very powerful tool, and it sounds like it did a great job. It can be quite expensive as well. I mean, there's no two ways about that, but it sounded like it did the job.
I think there's horses for courses, right? I certainly wouldn't, advocate every case we look at to say, look, Chapter 11, and there's been a lot of developments in Europe right? With the Part 26 and the Dutch WOA and cross-class cram down, et cetera. And each of those two jurisdictions have, their form. I don't want to say automatic stay, but stays of enforcement in one way or another. But Stephen, to your point, I think there are specific cases where you would look and say, okay, are a lot of the customers doing business in U.S. dollars? Could there potentially be an operational disruption? And going back to the specifics of our case, the multiple operational elements, I think, and anything that is similar in that regard, where there's an operational element or a carve out, while at the same time kind of holding everyone in abeyance and giving you the breathing space to do that, I think it's an incredibly efficient tool. To your point on being expensive, I hear you. It can be, but it can also be quite efficient in the sense if you have broad stakeholder alignment, you know what you set out to do. I mean, we filed on late November 2020, and we emerged on May 24th, 2021. Okay. And because of the degree of stakeholder alignment, we were able to use that safe breathing space to do what we needed to do. We had a clear vision of what we needed to accomplish. We planned it out. We executed it. At the end, we said, "Oh my goodness, what have we done? Can we actually pull this off?" But that's really what it can be used as a very efficient tool as well.
Got it. Well, we could probably spend all of our time on this, but I wanted to move forward a little bit. So, I mean, the story is that you eventually sort of set up this separate company. You ended up, it became very successful, and you ended up selling it back to Seadrill. Is that the final act?
That was the final act. There are a couple of acts in between. We did run it for 2 years. So when I said, at emergence, we said, "Oh my goodness, what have we done?" But we were able to do it. It wasn't a glide path by any means. Okay.
Yes.
When we emerged, I think day rates were at $250 a day, 250,000. And we had, by the time we emerged, we had one rig on contract.
Yeah.
So on an 11 rig fleet, and to your point earlier, yes, it is an expensive endeavor to have idle iron sitting around. So our stakeholders, our lenders, left us with $300 million in cash at emergence, but we had one rig on contract, and this was summertime 2021. And what happened, I really call it a proof of concept moment, is that BP in the Gulf of Mexico gave us our first contract. And this was really a big moment for the company, because all of a sudden, you have a customer like BP saying, "Look, we understand you have a unique operating model in the sense that you're a rig owner and someone else is operating it, but we'll do business with you." That was a big step. And shortly thereafter, we got a rig on contract with Eni in Indonesia. And we said, "Okay, this is kind of working." Now, volume was returning to the market at that time, and prices followed soon thereafter. And so by the time we sold the company, I think we had 4 rigs on contract, and rates were 400, 450, and pointing towards 500. So there's the cyclical. There's the other side of the cycle, right? And it worked quite well. So you're absolutely right. And then about a year ago, we did sell it back to Seadrill after running it for about 2 years.
Fantastic. I mean, this is the kind of story that I want on the Turnaround podcast. I mean, it's just a perfect case study of turning something around, taking a long time to do it, putting a massive amount of effort, and a success story at the end. So well done on that. And I was glad to share just a little bit of that journey with you, but tremendous, not just obviously you, there are many people involved in that restructuring. So
we must doff our cap to the cycle as well.
Yes, yeah, totally. You got your timing right as well. So you exited from that company. You were looking for something to do. Tell me what are you doing now?
I started with Province last year. So as soon as we finished really the closing processes of the transaction and the transition, making sure everything went smoothly, I joined Province. Province is a restructuring advisor, primarily based in the U.S. Okay, and really dynamic. Okay, both debtor advisory, creditor, litigation support, acting as trustee, independent director roles, independent director advisory roles, etc. So very dynamic. Frankly, I hesitate to use the word boutique. I mean, we're about 100 strong these days.
Yeah.
So really, it's quite an impressive platform, and also dynamic. We have a lot of people at our firm. Again, kind of using that analogy of kind of coming about this by accident, that got into the advisory role through practice. Okay.
Yeah.
Whether it be coming from distressed debt investing to moving over to the advisory side, coming from corporate, we have very strong industry verticals in both real estate and healthcare. Myself, of course, I bring along a heavy oil and gas component, but we are generalists and looking at a capital structure versus any single industry vertical and trying to attack it that way. And so when I was approached by Province, I had a look at the track record of some of the cases that they had worked on, the personalities behind it, and really the impressive growth story to date. And then I sat back and I said, okay, well, this is all very impressive. Now let's look at some of the structural elements in Europe. So obviously you've seen plans like Part 26 in the UK, Dutch WOA, German Stadtog, etc. A couple of years old, but really now starting to see some case law being built up and being utilized. Now, whether that's maturation of the law or cyclical elements, probably a bit of both. And I said, okay, well, that's interesting because a lot of the elements of the U.S. system are coming over to Europe. In particular, the ability to implement a cross-class cram down and really use these plans to attract companies to this jurisdiction to restructure. I also looked at the cyclical elements. Okay, I think we're all aware of the direction of travel on rate increases. I'm kind of in the camp that you don't cure a decade of low rates in a couple of increase cycles here, and I think that the cyclical elements from the rate cycle are playing out exactly as we expected, right? I mean, in companies where they're looking at refinancing needs, which more likely than not will be at a higher cost of funding, dealing with the impacts of inflation. I said, kind of combining Province's incredible track record and growth in the U.S. and bringing it over the Europe market makes a whole lot of sense. And so that's what we're doing.
So when we were preparing, you were saying you got pretty quickly involved in McDermott, which was obviously a very kind of topical recent name. Do you want to just explain, what the involvement was? Yeah,
this was a fascinating case to be involved in. I think, but it had a lot of elements to it. Okay, so just for all the listeners' benefit, McDermott is a U.S.-based engineering construction company. They had gone through a prior restructuring, I want to say in 2020, but companies in the engineering space, I think that a lot of their elements operate on fixed price turnkey contracts. And in an inflationary environment with increasing cost of funding, that's a challenging dynamic generally. This is not a McDermott specific comment at all. I think just businesses with those dynamics are challenged in this type of environment. And so what happened is there was an arbitration award in favor of the Colombian refining company called Reficar. Okay, they're owned by the state oil company Ecopetrol, and so it was a $1 billion arbitral award, which McDermott was going to have a hard time funding. And so what happened was, the respondents to the arbitral award were two companies within the McDermott framework. One was a UK company. The other was a Dutch BV. And so what happened was there was a Part 26 plan filed, as well as a Dutch WOA.
Yeah.
And so we had to represent. Look, we were really the fulcrum security here. This arbitral award, and so we represented Reficar in that case. And really the fascinating parts about this, and as you craft arguments in a type and advise in a type of case like this, is look, restructurings are complicated beasts. Okay, there's a constant decision making framework, and how is this element going to impact this, and when you put two court systems on top of that, it creates a very dynamic atmosphere. Okay. And especially when you look at the two, call it the comparative in the two systems. So in the UK Part 26 plan, what you're doing is it's obviously the no worse off test to the relevant alternative. In this instance, and in many instances, the relevant alternative is the debtor says, look, it's liquidation.
Yeah.
But if you compare and contrast that to the Dutch WOA process, it's putting aside if this is a straight liquidation and kind of a fair distribution of liquidation proceeds, what they will look at if the restructuring plan is to have a going concern value, they'll say, okay, well, is this an equitable sharing of the restructuring surplus?
Yeah, right.
Okay, and so it's two very different comparatives.
Yes.
What was quite interesting is that there was $2 billion in letters of credit. Okay.
Yeah.
And what we had to think about is, when do these letters of credit actually become debt? Because in a going concern scenario, they're just contingent liabilities. These were not financial LCs. These were performance LCs. So in a going concern, business continues to perform. LCs don't get called. It's a contingent liability. It's not debt.
Yeah.
However, in a liquidation scenario,
they've got a claim.
Some of them may be debt, some of them may not. We need to look at what the claims are going to be on each LC. But for ease of comparison, let's just assume in a liquidation they're debt, and in a going concern they're not. This was a $2 billion swing factor. So it almost put us kind of entirely in the money or entirely out of the money. And so when you overlay not only two different bases of comparisons, but also the impact that has on the waterfall, you really had to be deliberate and cautious and thorough in arguments you might be making in one court setting versus arguments you might be making in another. And so, the importance of kind of, okay, this is the plan. Well, why don't you go back around it? Let's go back around it again. Let's keep making sure, and then putting aside the fact that if one court goes first and the other one doesn't, or vice versa, that might change your argument. So you could imagine the depth of the playbook that you had to have or had to develop as you were entering into these proceedings.
Yes. Yeah. And how did it end up getting resolved, John?
So there ultimately was a settlement. Okay. It really this battle was mainly fought in the Dutch courts. Okay, because obviously when you look at the it was a matter of the going concern and the equitable sharing of the restructuring surplus that really formed really where we're going to have the strongest arguments. Okay, because in the UK courts, we had to run a very nuanced argument that it was not, the debtor side it was immediate liquidation, and we said, well, actually, we think it's 180 days or, a short period of time down the road, which gives us adequate time to negotiate, which is a settlement, which is ultimately what we're here. It's not immediate liquidation today. There is a small amount of time. I think the court, the UK courts began as being sympathetic to our cause. But, what happened in the middle of it was a 6-day trial in the UK. What happened in the middle of it is that the Dutch courts came out with a recommendation that if we do not object to the plan in the Dutch process, that we get 20% of the equity at Topco, and if we do object, then we get 10%.
Yeah, I mean, I think I mentioned yesterday that there have been a number of cases in the UK on the relative alternative, and judges haven't been they don't just accept, oh, you say it's liquidation, I'm just going to accept that. There was one case that sprang to mind, Hurricane, where it was a producer which had some technical issues. It had debt that perhaps it was never going to pay off, but it was going to take quite a long time to work out, how much revenue it really was going to produce and how long it would take effectively to go insolvent. It would go insolvent eventually. And I think the judge basically said, look, I'm not just going to accept that tomorrow morning it's going to go into insolvency. You need to think again. So I think a lot of this is evolving case law. There's going to be a lot of future discussion. But I actually just think it's such an interesting case study. I mean, you basically have two courts that, in some ways, you may be arguing something, completely contrary to the what you need to have in the other court. So it must have been a very tricky fine line that you were having to step on all the time.
Yeah, it was, and also I might say a moving line, right? Because orders and sequencing might change, and I can't leave out there was also a Chapter 15 recognition process ongoing as well, and so look, it has procedural elements. It has ability to introduce evidence, take depositions, etc. So there's a lot of factors that you really need to navigate through. And from Province's perspective, I think there's also a lot of understanding how businesses work. Okay, let's just and I think this is when I think about our firm and some of the capabilities we bring. People who have come from operating businesses. So in real life, in the business world, this is how the LC is going to work. This is how a performance LC is going to work in practice. Now let's look at the documentation. Are there different enforcement terms? Let's see who owns the LCs. Okay, and really understand. Let's look at the cross holdings. Okay, where are different owners of certain LCs exposed elsewhere? Are they incentivized? Where are the economic incentives to take certain actions reside? And so there was a big body of work put behind that in support of counsel to kind of craft and frame these arguments. In addition to being dynamic and being able to adjust real time for the arguments of the two court systems, or three.
Yeah. So I think you've just brought two great case studies to the Turnaround podcast. So thank you for that. Very interesting. What do you think you're going to be doing over the next sort of 3, 6, 9, 12 months?
Yeah. So look, we are, there's no question in my mind, volumes are picking up. And this is not a Europe comment. This is a global comment. Okay, and we are seeing, and it's probably won't come as a surprise to you or any of the listeners, but real estate retail are some of the hot spots. But I also bring up, coming back to I don't want to say engineering and construction specifically, but companies that are doing fixed price turnkey contracts or with long-term contracts that are exposed to a rising interest rate environment, as well as an inflationary environment with challenged supply lines. I think these are a lot of areas where we're getting several inbounds.
John, we've taken a lot of your time. I've really enjoyed today's episode. It got a couple of good case studies. Obviously, I wish you good luck as you expand in Europe, and no doubt we will be seeing a lot of you in the next few years. So thanks for joining us.
Yeah, my pleasure. And Stephen, thanks for having me on. I think you've had great lineups so far, and very happy to participate and become one of the lineup.
Great. Thanks. Bye.
You've been tuning in to the Turnaround Podcast with your host, Stephen Phillips. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, freilibertas.com. Thank you for your positive reviews, comments, questions, and for sharing this show with others.